May I say one thing before
Yes,
this?
you can.
I think Ms. Anderson deserves this, and I'll try to keep my voice down and my blood pressure down. But I hope the court will appreciate that those are very difficult allegations to listen to.
I do.
And if I may, Your Honor, I should be more like you and not take things personally. We all should. But there is not a lawyer in the courtroom who deserves the allegations less than Ms. Anderson does. And in the 25 years I've practiced, I've never known a more honest, faithful, and true attorney than she. And I regret very much that her name is on the record associated with these allegations. I'm going to do my level best tomorrow to convince you that there's not a damn bit of truth to them.
All right. Department 16, now go back to order. Please be seated. What do you mean?
Shane, can you put Exhibit C back on?
I'll take care of it. I'm here for him right now.
Okay, good enough. Your Honor, may I proceed?
Oh, yes, you
Thank you, Your Honor. Exhibit C, Shane. So, Your Honor, this is the affidavit of Craig Shank. And as we've learned from the other affidavits, Mr. Shank is the employee who put together this information that the attorneys asked for. So if we could allow Mr. Shank to introduce himself through page 2 of this document. So he's a graduate of the University of Wisconsin, Whitewater, where he obtained a Bachelor of Business Administration, and then he obtained a Master's of Business Administration from Texas State University. Additionally, he has a data analytics certificate from the University of Texas at Austin. So it tells us certainly what his education is in. And then on paragraph 4, he tells us, informs us that he's employed by Amazon.com Inc. and that Amazon.com Inc. provides data, analytical, and other services to its subsidiary and indirect subsidiary companies, including Whole Foods Market Services Inc. and the operating companies which run Whole Foods Market, collectively Whole Foods. While he's employed by Amazon Inc., he is a dedicated business intelligence engineer, providing services exclusively for Whole Foods. And then he says, I analyze only its data. Now, as soon as I saw that sentence, I wondered to myself, why don't we have a custodian of records, not someone who's analytically reviewing data, simply a custodian of records providing data. Typically, Your Honor, you've seen it yourself, the affidavit from the custodian says, I've done a search, here are all the documents. That's what typically you would have in a 16.1 setting or discovery setting. But that's not what we have here. We have someone analyzing the data that we're entitled to under 16.1, telling us what he's going to give us based upon his desired SQL search. That's what we can determine just from this one sentence.
And is SQL, is that the term, is that their term? Because normally we look at it as an ESI protocol.
Sure, we do, and that's what it should be. We should have had a protocol here. Or we should have had at least an indication of what protocol is going to be used to respond to our request. But the SQL is the structured query language that a person, or in this case, an intelligence engineer, would use to define parameters on a search to retrieve information from a collection or universe of data. That's what this person did, using his own words, which they have shielded from us. We don't know what the SQL language is. And the affidavits say that the SQL was work product. So it was scrubbed. And it says, I work daily with Whole Foods sales data, again, data, and are familiar with the data and the process used to collect the same. That's what we want, a collection of the data. That's what 16.1 requires. Not your desired, as an attorney, spreadsheet created by your in-house employee based upon his discretion to come up with some search terms. And that's what happened here. Paragraph 6 says, Whole Foods R10 point of sale system records data, love the word data, detailing all purchases at Whole Foods markets at the time those purchases are made. So that's the contemporaneous business records that you're accustomed to dealing with, which is an exception to the hearsay rule, which we're entitled to. That's what he's speaking of. That's the information we're entitled to. That's what we did not receive. At the point of sale, the UPC code on each item is scanned, and the items collectively comprising a purchase are totaled, and data concerning the transactions, including an itemization of all individual items comprising a transaction, are contemporaneously electronically recorded in the point of sale system. And that's what we want. We want this information from their point of sale system that's electronically stored. Going back to what you said, Your Honor, the ESI protocol. Which means every single real water bottle could be matched with dates of sale. So imagine that, Your Honor, if we actually had the data, we could compare that to the days Mr. Haley worked. We could compare it to the days and times when he's on break. He testified during his deposition, quite often he would buy water during his break. We could compare that information to what he recalls and could have used that information in his deposition. We could have used it in our discovery request. We could have used it when we're deposing their employees. We had none of that information. Further, it says on paragraph 7, the cash registers or point of sale terminals use the point of sale system data to generate store receipts. Now, this is what I found to be so hypocritical. When our client was being criticized for not having receipts, or at least being mentioned, you have no receipts, you have no paper to prove you purchased it. The next sentence says, no paper records beyond the paper receipt are generated when a purchase is made. Instead, the point of sale system retains the underlying data electronically. A confirmation that the information is there. We should have it. This court should have it. It should have been given the whole of it. Now, if you do a cash sale and you don't use identification card or any other identifying card, then they would not be able to, or at least I believe based upon this these two paragraphs, they would not be able to say that Mr. Haley or Mr. Belsky didn't buy it, because what they would show was a cash purchase without identification through a credit card or through an employee card. They would just have a cash purchase on their history using a UPC code, which again, we could use to match up potentially with our client's work schedule, which we didn't have. Paragraph 8 says, the data recorded for each transaction includes but is not limited to the transaction date. Again, that goes back to what I was saying, Your Honor. Potentially we could have matched the raw data to our client's date of work hours and days working. The store number, again, we can match them up to the Reno Whole Foods, or in the case of Mr. Belsky, the Fort Apache location, or the Lake Mead location. The terminal register, cash register number, potentially we could have matched it up to Lori Kingston or Sarah Sandstrom. Transaction number, transaction time, store name, region name, all of that information would have been in the data, raw data, not Excel spreadsheets, but raw data that we potentially, in a cash purchase situation, we could have matched up to our client. For each item purchased in the transaction, an item description, the item size, unit of measure, the department in which the item is stocked, the number of units purchased, and the purchase price. All of that information would be in the store records or electronically stored by Whole Foods. When a purchase is made using either a credit or debit card, an Amazon Prime account, or an employee identification discount card, that transaction is associated with that unique means of identification. Again, it excludes identification through cash purchases, Your Honor. So to the extent Mr. Belsky or Mr. Henry used cash, it would not be recorded, but it would be recorded in terms of the time to purchase a store, but nothing directly identifying them by a credit card number or an employee card. Now I'm going to skip over to paragraph, I'm sorry, go ahead.
Given what you just said, you should probably read paragraph 11.
No worries. Page 11, paragraph 11. Maybe this will save Mr. Neale some time. When a prime account or employee identification card is used, which I discussed, that data is available regardless of whether the purchase is made with a credit card, debit card, or cash. Again, I've already discussed that, but I will explain it a little bit more so maybe we all understand in the room. Again, enabling Whole Foods to definitively identify all transactions linked to the same prime account or employee identification discount card. I'm going to take it slow so we all understand this. Bring the top of this down. So what I believe Mr. Neale is pointing at is that if they use cash, it's still recorded. What he didn't understand apparently is if you use cash with your employee identification card. Let's say he decides not to use his employee identification card to get some 10 cents savings on that bottle. It's not recorded. That's the point, John. The only way they record it, even if you use cash, is if you use your employee identification card. That's it. So for every purchase done without that identification card with cash, we would be able to look through the raw data and figure it out. That we were not able to do because they never produced the raw data. Now, going to paragraph 12. What Whole Foods point of sale system stores this contemporaneously recorded data, not Excel spreadsheets, and then on a daily basis transmits the data for all transactions in the store to Whole Foods data warehouse system. That's what we want. We want all that information from that Whole Foods data system, warehouse system. That's what we have not gotten. We've not gotten the individual store data. We've not gotten the Whole Foods data warehouse system data. Are you with me?
No, I'm with you. I was just.
Perfect. At the Whole Foods data warehouse, the data is stored electronically on servers maintained by Teradata, a global leader in data warehouse solutions. You remember this. This is the ESI that you're talking about, and you're familiar with Teradata because Teradata has come before this court before in terms of storage of electronic information. It came before you, it came before, I believe it was Judge Weiss in the Actos case. We don't have this information. We were never given access to the information. The data is collected, stored, and maintained in the normal course of business. The collection, storage, and maintenance of this data is a regularly conducted business activity at every terminal in every Whole Foods market. Now, this is what I love. He's already told us in these first two sentences what's collected and what's kept in the normal course. And he says the data is not recorded for purposes of litigation. I agree with that. That's what we're entitled to, the data that's not created for litigation. Every purchase is not designed to be used in litigation. We understand that. And so I agree with him. The data, the raw data we're looking for, is not stored in preparation or anticipation of litigation. These Excel spreadsheets, on the other hand, were done exactly for that purpose. Because they were done by the request of counsel to another attorney who then gave authority for Mr. Shank to do these spreadsheets with these secret SQL language and then provide it back to an attorney who decided whether or not, after looking at it, should we produce it to the other side. That's what happened. Paragraph 15. Whole Foods has a substantial interest in ensuring the sales data it collects and stores in its Whole Foods data warehouse is accurate and comprehensive as part of furthering its business interest. It says, in particular, Whole Foods analyzes the Whole Foods warehouse data in making a variety of strategic business decisions, including decisions analyzing what merchandise to stock and when, setting prices, and it goes on and on. Now, Whole Foods has the ability to analyze its data. Not his spreadsheets created for purposes of litigation or his spreadsheets created by Mr. Shank, but it's raw data. It keeps speaking of data, and then he tries to transform this data into a spreadsheet, which are two different things, and indicating by saying that somehow they've complied with 16.1, and they haven't, John. The last sentence in this paragraph says, in addition, the data is regularly used, as it was in this case, to respond to discovery requests in litigation. That's, again, a departure from what's happened. The data hasn't been provided to us in this litigation. His spreadsheet has. A business intelligence engineer can employ a computer programming language known as, here we go, structured query language to define search parameters with which to query the Whole Foods warehouse sales data in any manner needed. Your Honor, here's your admission from Mr. Shank. He now tells you this is what he did. He doesn't tell us the search language again, but he defines the parameters, as opposed to 16.1 defining the parameters.
Or actually, maybe opposed to me defining what the search parameters are after a discussion regarding what the search parameters should be.
That's
And
right.
I've done that many times in litigation.
Yes, you have. That's exactly right, John. But this guy in Texas, apparently, decided on his own what language he would use without any regard for 16.1 and gave us what they wanted to give us. And that's what we got. We don't have the native data, electronically stored or otherwise. Paragraph 17. In response, the warehouse data system database produces all data responsive to the SQL. This is amazing. When this affidavit was being prepared, someone had to type this out. Produces all data responsive to the SQL query in the form of an Excel spreadsheet. The person who prepared this gentleman, there's no way he could have not seen that he was defining the discovery in this case. What he was going to produce in response to requests, lawful discovery requests, he was defining it without consideration of our rules. Providing the detailed data responsive to the engineers. Again, this just heightens it. The engineer's particular request and satisfying the specific parameters in the SQL query. No consideration for 16.1. It's been defined by Mr. Shank. The spreadsheet is simply a compilation of electronic data that was recorded contemporaneously when each individual transaction satisfying the query parameters were made. Again, he's setting the parameters. The data is not recorded or maintained for litigation purposes, which that's one thing we agree to, but instead as a regularly conducted business activity of Whole Foods. The data is, not the spreadsheet. He's defined it and separated it for us. He's decided, Your Honor. Not lawyers, not a discovery commissioner, not this court, not our rules. He decided what he's going to produce based upon his query that he, in his discretion, thought was appropriate. He received 7 different job requests for Whole Foods sales data that I understand, I love these conditional responses, that I understand relate to this case. Each request for data that I received asked for all sales data. Again, he's now confirming what we're asking for. He knew we wanted the sales data. Related to Whole Foods purchases made using either a particular employee identification card between certain dates, ranges made using particular credit cards, or certain dates. Now, look at that, Sean. Not cash. And I appreciate Mr. Neale asking me to read paragraph 11, because this further heightens and brings a sharper point to the issue. None of the cash purchases are identified in the Excel spreadsheet we were given. None. Zero. So if he bought a bottle without using his ID card with cash, it's not reflected in that spreadsheet that was used in all the depositions. Paragraph 20. For each request, I drafted an SQL query matching. Now, I don't know that the same SQL was used for each search. He had 7 searches, and he doesn't tell us what the SQL search language was for each one. So he says, for each request, I draft an SQL query matching the request parameters, and then query the Whole Foods data warehouse system, which is what we want. Now, paragraph 21 tells us, starts giving us information about the storage yard. The first request for purchase data pertaining to an individual whom I understand to be a team member at a Whole Foods Market store in Reno, Nevada. So that's the Reno store. And that would be Plaintiff Haley Young. I was originally provided transaction data, store number, date, transaction amount, from June 23rd, 2019 through August 2019. Then he gives a number, which is the number of the ID card, supposedly.
No,
I'm sorry, card number. Then he provides, thank you, Mr.
it's a credit card.
Okay, I can go with that. A card number, Your Honor. He'll correct us in a second. However, I determined the card number did not appear to match any transactions. I do not believe United States card numbers can start with a 0. Therefore, I obtained Mr. Haley's discount card, which is the one we've been talking about, from Jennifer Choi of Whole Foods Team Member Services. Now, for someone who has no control over Whole Foods information, they're able to get in-house counsel, their chief intelligence engineer, Whole Foods team members. They're doing a lot.
Well, you have to remember, Rule 34 is much broader than that. It's in possession, custody, and or control.
I agree.
And control is really broad. I mean, it's,
That's right.
we can delve into that, but it's even discussed in Moore's Federal Practice and Procedure. That's a big deal, but go ahead.
And that's why I brought up the relationship between the counsel, between the in-house counsel, how much access they have, and in my opinion, control over these documents. So then he continues on saying, subsequently, I've confirmed that the number she provided for me, for Mr. Haley, is the same without a check digit, as that on the employee discount card that Mr. Haley produced in this litigation, and then he gives the date.
The only reason I bring that up is I'm straight out of Moore's. This is section 3415 2B. It defines, and we, Nevada now, I guess this is actually really good for us. We decided to go with the federal rules, and that gives the trial courts, specifically, I guess, from a residential perspective, a lot more interpretation of the rules of civil procedure. And here's kind of my point, and this is straight out of Moore's. It says, quote, legal ownership of the requested documents electronically stored or things is not determinative, nor is actual possession necessary if the person has control of the item. Control has been defined to include a legal right to obtain the documents requested upon demand. The term control is broadly construed, and I'll stop there. But they cite a ton of cases from 1st, 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, 9th, 10th, and the DC Circuit.
Yes, sir. And that's, that's a very, very, very good point. And like I said, I started this so you could understand the relationships between the attorneys and the parties, and alleged non-party, of course, in this case, was a party to other reward cases, the ones that Ms. Joan Anderson represents Whole Foods in. So paragraph 22 says, I reported the results in my query in an Excel spreadsheet that I entitled, it's DT 13645, Reward of Edge Contamination Cases. I provided it to counsel and understand that it was produced in the litigation as a native Excel file, again, talking about the spreadsheet. I performed an electronic comparison of the spreadsheet I produced and confirmed that the data was not modified at all prior to production. Now, this is what I said to you earlier. The only change made to the spreadsheet that I provided prior to its production in this case was to change the file name. If you go to paragraph 23, because paragraph 23 talks about the next 4 transactions using Mr. Haley's employee discount card, the last sentence in paragraph 23 reads, the only changes made to the spreadsheet that I provided prior to production, in this case, it's Whole Foods 636, were to remove the tabs where I included my working SQL code and to change the file name. So that's what I've been saying all this time. They removed the SQL codes. We don't even know what search parameters were created in terms of words. We have no idea. And they removed it because they didn't want us to. Paragraph 24, Your Honor. After paragraph 22 talks about the first results. Paragraph 23 talks about the next request that he received from Mr. Haley. Paragraph 24 talks about the request for 5 separate purchases in 2018 at the Lake Mead location in Las Vegas. So that's Mr. Belsky. And if you go to the end of paragraph 24, again he says in terms of the Belsky investigation, the only changes made to the spreadsheet that I provided prior to its deduction in this case as Whole Foods 638 were to remove the tabs where I included my working SQL code and to change the file name. Now, he has done that, Your Honor, with the Haley request, with the Belsky request, the Reno store, the Lake Mead store, and in paragraph 25, the Fort Apache store. And he gives again the dates in 2018, in the months. And he talks about in paragraph 26, the request for all transactions using Mr. Haley's employee discount card for the fall of 2019. And again, he tells us that he didn't make any changes to the spreadsheet, other than the change in the file name. Then in paragraph 27, he says the same. And he gives the parameters in terms of the dates. Again, everything in terms of Haley is used identifying his employee discount card for 2018, 20, 21. And it says that in paragraph 28. And finally, he says that the paragraph 29, the purchase data reflected in the spreadsheets was not modified in any manner prior to production. So, Your Honor, this was signed July 6, 2023 by Mr. Shank. In approximately 2 weeks or so, or 8 days before Ms. Anderson signed her affidavit. Now let me just show you how this spreadsheet was used, just to give the court some flavor on this. Let's go to Belsky's deposition, Shane. Page 95. No, I'm going to approach, okay?
You can,
Thank you, sir. It says here, question number 10, you've given us some American Express, I guess, or Amex bank or credit card statements. I think you're up on the screen now. You're showing this in the deposition on the screen. I think it may have been a Zoom depo yard. Do you recognize that as your account? Yes, I do recognize that. And I take you went back and tried to provide the Whole Foods purchase data that you found on your credit card. Correct. Do you have any credit cards? Yes. Did you make any Whole Foods purchases with those? Yes. Now, I point that out, Your Honor, because Mr. Neale, I believe, took this deposition. It's my belief. And he was trying to examine Mr. Belsky, suggesting that if you don't have credit card purchases showing that you purchased real water from Whole Foods, perhaps you didn't. Or perhaps you don't remember. Or perhaps you didn't purchase as much as you thought you purchased. This is how it's used. Now, I'm going to show you a more frontal attack. This is kind of a nuanced one. I'm going to show you a more frontal attack with Haley. Page 147, Haley, please. He said, we got what we understand to be your employee discount ID card history. That's Mr. Neale again. And he says, we've got your debit card statements, correct? Keep going. The witness says, look like it. So we've shown you both of those. So I am, with that, we should be able to go back and match your debit card purchases to the employee card discount card spreadsheet. So that's Mr. Neale using the spreadsheet to suggest that if it's not in the spreadsheet, If it's not on your credit card statement, perhaps you didn't buy real water. That's how you use it with Mr. Haley. Now let's go to Lori Kingston. Page 28. Now, Mr. Neale, you see by Mr. Neale, I'm going to show you some data in just a second. Has Mr. Haley told you that he's asked for the employee purchase data in this case? Witness says no. And he didn't tell you that the employee purchase data, as Mr. Pepperman alluded to, failed to show any real water purchases, at least in 2019. Now that's Mr. Neale using this against the sword. Witness says no, he did not tell me that. Keep going. Let me pull up that and show it to you. I'm going to start, ma'am, Ms. Kingston, with this spreadsheet. I hope you have a bigger screen in front of you where you can see something if I pull it up. Now he's using the spreadsheet, not data, but the spreadsheet to influence a witness's testimony to say, well, it's not on the spreadsheet, maybe the purchases didn't occur. Now she said, I believe previous to this, that he purchased 10 to 20 that she could remember.
Page 11.
Let's go to page 11. This is before the spreadsheet comes out. Let's see, where is it? Keep going. During the time period between February and August of 2019, did you ever personally observe Keith Haley drinking a brand of water called real water? Yes. Are you able to give us an estimate about the number of occasions in which you personally observed Keith Haley drinking real water? I don't recall. What is the multiple times? Would you describe it? Was it more than 20 or 30? Didn't go up? I feel he bought it very often, so between 10 and 20. Now, after having that testimony, Mr. Neale comes in a few pages later, and Your Honor, you have that, I believe you may have that deposition transcript because of one of the items we talked about on day one. He then goes into that spreadsheet. Maybe your recollection is not what you think it is, because the spreadsheet doesn't show 10 or 20. Now, finally, let's go to Sarah Sandstrom. I believe this is on page 21. Now, he asked, Mr. Pepperman asked Ms. Sandstrom, do you have any information at all about Whole Foods, about how Whole Foods maintains its purchase data? Give me a second to think. We have buyers in each department, and they scan the outs on the shelf with the Honeywell, and I print that out, and they print out like purchase orders. Feel like I would know, but on the spot like this, I don't. I don't have because I never, again, had personal experience. So you have no information on how Whole Foods maintains its credit card history or product purchase data? No. As a customer, I just noticed, I was like, something is gone, it's very heartbreaking sometimes. I bring that up, Your Honor, because all of these witnesses, current Whole Foods employees, Ms. Sandstrom and Lori Kingston, are providing information. And at one time or another, they're confronted with an Excel spreadsheet that does not look like a receipt or purchase data that you would normally see. And their recollection is being tested. We are deserving of the data. The rules require the production of the data. If there's an electronic storage issue, can you inform us at least of the opportunity to get the information? We come up with an ESI protocol, something. But what you don't do is determine on your own what SQL language to use, set your own parameters, and then remove the SQL information so we don't know what you used to create the parameters, then give us what you intend to use in litigation. That's not how the rules work, Your Honor. Your Honor, unless you have any questions for me, I will be more than happy to turn this over to Mr. Neale, I suppose, but I will indicate in closing, Your Honor, that under Rule 37, which is referenced towards the end of Rule 16.1, that violation of Rule 16.1, government of Rule 37, requires some form of sanction, some form of address. And under the Young versus Johnny Riviero case, I believe an evidentiary hearing is in order. Thank you, Your Honor.
Thank you, sir. And I would anticipate, Mr. Neale, you're gonna need some time.
Yes, sir.
Okay, we'll try to be fair in that regard. Because right now, it's basically, what, 4:30?
Yes, Your Honor.
And, what time did we start tomorrow?
We start at 1:15, Your Honor.
1:15, okay. I just wanted to make sure whether this is a morning session or not. You ready to go at 1:15, Mr. Neale?
Yes, sir, or now, whatever the court's preference is.
But I know you're gonna take more than 15 minutes.
Yes, sir.
So we're going at 1:15.
Yes, sir. May I say one thing before
Yes,
this?
you can.
I think Ms. Anderson deserved this, and I'll try to keep my voice down and my blood pressure down. But I hope the court will appreciate that those are very difficult allegations to listen to.
I do.
And if I may, Your Honor.
I don't want to cut you up, but one thing you have to understand is this. And I think one thing almost all the lawyers at Brad, they might not think, they might have issues with some of my decisions, but I never get upset. And I really don't. I don't get upset at all. I've never lost my temper. I sit back objectively, and I realize there's been some allegations, but I'm gonna listen and give you a chance to speak your piece. And just as important too, wait, if you want to add anything else.
I want to add one thing, if I may, Your Honor. I should be more like you and not take things personally. We all should. But there is not a lawyer in the courtroom who deserves the allegations less than Ms. Anderson does. And in the 25 years I've practiced, I've never known a more honest, faithful, and true attorney than she. And I regret very much that her name is on the record associated with these allegations. I'm going to do my level best tomorrow to convince you that there's not a damn bit of truth to them.
I understand. And anyway, I'm going to give you an opportunity at 1:15 to do that. How's that, Joe?
Sounds great, Your Honor.
Your Honor, I want to again thank the court for letting me do this. I told plaintiff's counsel, I told the defense counsel, I am doing some pro hoc stuff, and not pro hoc is the wrong word for it. I'm doing some volunteer work out with prison, and
Doesn't count if you brag about it, Scott.
doing that, and the training is tomorrow. You're right, Jim, I didn't mean it to brag that way. That may have sounded like a brag. I didn't mean it to be that way, and I don't want the court to, bring that into, probably shouldn't have said anything, but I appreciate the court's indulgence in letting this go at that time.
Absolutely. You've been in front of me a lot.
I have been here on hundreds of CD cases.
All right. Everyone enjoy your evening, and we'll continue on at 1:15 tomorrow afternoon.
Thank you, Your Honor.
All right. Thank you, ladies and gentlemen.
Department 16 is now set on Tuesday, presiding.
You have to share that.
Please be seated.
And I want to say good afternoon to everyone. Let's go ahead and set forth our appearances for the record.
Good afternoon, Your Honor. Eric Pepperman, Plaintiffs.
Good afternoon, Your Honor. Teddy Parker on behalf of the plaintiff.
Good afternoon, Your Honor. Jim Neale on behalf of UNFW.
Shirley Anderson on behalf of UNFW.
Good afternoon, Your Honor. Joel Ledoux and Matthew Kaufman from remote on behalf of the Milwaukee Instruments. Good afternoon, Your Honor. Rob Robbins from Milwaukee Instruments.
Good afternoon, Your Honor. Scott Rasmussen, I'll be pretty live on behalf of Canada.
Good afternoon, Your Honor. Jim Cavanaugh, Gordon Reese, Las Vegas, on behalf of Rural Water Tennessee, LLC.
Good morning, Your Honor. David Spurlock, United Natural Service.
Okay, did we cover all appearances? Just want to make sure. Okay, once again, I just want to say good afternoon to everyone. And I guess we're going to continue as to where we left off yesterday. Is that correct?
Yes, Your Honor. I just have one housekeeping matter I wanted to raise with the court.
Yes.
With respect to the jury questionnaires that we've received and stipulated to the excusals, the jury commissioner has asked if we could submit the list of stipulated excusals to the commissioner's department so they can start excusing the jurors that we've agreed. I talked to Mr. O'Dew about it, no objection from him. I just wanted to confirm that there was no issue with the stipulated excusals with your honor before we submitted the list to the jury commissioner.
There's no issue there whatsoever.
Okay, thank you, Your Honor.
Is there anything else we need to do regarding selection? Okay, I guess we can continue on, and I think we left off with Mr. Neale, is that correct, sir?
I believe it is, Your Honor.
You can see we've improved the seating for everyone. All right, sir.
Thank you, Your Honor. Jim Neale on behalf of UNFW. And before I get started, substantively, Your Honor, one of the binders that the court should have is a very large binder full of oversized spreadsheets that is labeled subject to protective order, UNFW's opposition to plaintiffs at MIL number 16. It's an overlapping topic, and that's the first one we saw.
There's so many here.
I can give this one to the court if
What color is it?
you don't have one handy.
I got it. Yeah, can you just hold for 1 second?
Yes, sir.
What's the title of it?
Thank you, sir.
May I approach it?
Yes. And I'll just step down for 1 second.
Thank you.
Okay, sir.
Thank you, Your Honor. Your Honor, again, Jim Neale on behalf of UNFW, here to address the plaintiff's motion to strike my client's answer. Your Honor, I want to start exactly where I finished yesterday, which is to state, this time on the record, to the extent it wasn't last night, that I have just unfailing confidence in Ms. Anderson and the work she's done. And if there was a failure here of any sort, I'm certain it's mine. I'll tell the court why that's not the case, but I haven't had a harder 90 minutes in court than listening to a fine lawyer like that be maligned, and I don't know how to better state it. We were accused, Your Honor, yesterday of manufacturing, in the course of this motion to strike, we've been accused of manufacturing evidence, of modifying that evidence substantively, of sitting on that evidence to gain an advantage, and of lying to witnesses and misrepresenting facts to the court. Those things, Your Honor, are categorically false. That did not happen. We're here, Your Honor, without having served 7 different discovery responses to informal requests, responses to formal requests, and everything in between. What I find remarkable is that there was never a meet and confer on any of these issues. There was never a motion to compel. There was never an item placed on the special master's agenda. And yet, here we are seeking the ultimate sanction to deny a party its day in court. I think that should suggest to the court, or it certainly suggests to me, that what this is not an attempt to discover the truth. It's not an attempt to enforce the discovery rules. This is an attempt to do just the opposite and to keep this truth from the jury. The plaintiffs in this case, Your Honor, got exactly what they asked for. And at the same time, exactly what they didn't want. And days after getting that, they filed this motion. The argument yesterday makes me wonder if the plaintiffs read any of the 16.1 disclosures we filed in this case. I think there was the original and 19 supplements. If they read their own discovery requests and the instructions that they attached to them. Or if they read the data that we produced in response. In front of you, Your Honor, is the binder with 8 tabs, the first of which is the affidavit of Mr. Shank, which Mr. Parker went through at length yesterday. And the next 7 of which are the Whole Foods data, purchase data, for Mr. Haley and Mr. Belsky and their various iterations that we were asked to produce by plaintiffs in this case. That collection of documents, Your Honor, is what was described by Mr. Parker yesterday as 8 pages. Something tells me that somebody who describes this collection of documents as 8 pages has not spent very much time with them. Had he done so, I think he would have had a better idea of what's in there and what's not in there. In this case, Your Honor, we disclosed the fact that this data existed. In our second supplemental, we alluded to it in our first. We disclosed the fact that it existed in our second. We disclosed that, we reiterated that disclosure in the next 18. And we identified a 30B6 witness in the second one as well, and every one thereafter. We identified each and every one of those documents in front of you. And we identified Mr. Shank by name a few days prior to the close of discovery in the 19th supplemental 16.1. As I said, Your Honor, we responded to emails, we responded to letters, we didn't insist on requests for production. We responded to discovery requests that were served on Whole Foods and other cases that dealt just with Mr. Haley and Mr. Belsky. We didn't stand on a formalistic objection. We responded to discovery that was served in this case, even though Whole Foods is not a party. You may have been lent the impression yesterday, or the misimpression, that we stood on an objection and said we don't have possession, custody, or control over these documents. We never did any such thing. We took each and every request we got from the plaintiff, and we promptly relayed it. And when I say we here, I shouldn't take credit for Ms. Anderson's good work. We promptly relayed it to the Whole Foods contact we had. And then we rode that contact as hard as it was necessary to ride that contact to get the data. We produced it in exactly the form the plaintiffs instructed us to produce it. I'm going to say that again and show you the instructions, Your Honor, because I know the court had an ESI question.
And before we even go there, I just want to make sure I understand specifically what's contained in the, I guess, the documents that would have been attached as the opposition to plaintiff's motion. What do we have here? Just so I know what I'm looking at.
Yes, sir. At tab number 1, you have the affidavit of Craig Shank. Mr. Shank is the Amazon employee, the business intelligence engineer who ran the SQL queries and collected these documents. At tab number 2, Your Honor, the next 7 tabs are the spreadsheets themselves, the underlying data. The first of those is tab 2. That's Whole Foods 181. Those are the purchases associated with Mr. Haley's employee ID number for approximately a 2-month period before his August 13, 2019 hospitalization. Tab number 3, Your Honor, is Whole Foods 636. 636, Your Honor, is a larger collection of Mr. Haley's itemized purchases. It includes all of his employee ID purchases in calendar year 2019. Cash, credit card, gift card, employee bonus card, everything. Tab number 4, Your Honor, is Whole Foods 637. That document, Your Honor, are the transactions associated with one of Mr. Belsky's credit cards, the first one we were given. It is not date specific, it is not store specific. Tab number 5, Your Honor, is Whole Foods 638. When Mr. Belsky was deposed, he disclosed the existence of other credit cards he had not yet provided. He subsequently did. 638 shows the transactions at Whole Foods associated with those credit cards, excuse me. I believe there were 3 credit cards, 3 different stores. 98 items are included on that spreadsheet. Tab number 6, Your Honor, is Whole Foods 639. That document, Your Honor, is also Mr. Haley's 2019 employee ID purchases. We were asked to supplement the prior iteration of that same data to include the names of the products themselves rather than just the UPC code. And of course, we did that promptly. That has 2,644 separate items on it. Tab number 7, Your Honor, is Whole Foods 640. That document, Your Honor, I'll have to remind myself, forgive me. That document are additional credit card transactions in Mr. Belsky's that were again later reported. Different stores, different credit cards that he supplemented his discovery request with. And then finally, Your Honor, tab number 8, the largest spreadsheet of all, is Whole Foods 641. At the plaintiff's request, Your Honor, that data includes all of Mr. Haley's employee ID purchases, cash, credit, gift card, employee bonus card, for a time period of January 1st, 2018, approximately 21 months prior to his hospitalization, to December 31st, 2021, more than 26 months after his hospitalization. And that document, Your Honor, which I guess Mr. Parker understood to be one of the 8 pages, actually details 1,500 separate transactions and 5,503 separate items purchased, including one 500 milliliter bottle of real water that Mr. Haley purchased using his employee ID number on March 5th, 2018, 16 months before he was hospitalized. That is the one and only purchase, Your Honor, of any retail real water by either of these 2 gentlemen that has shown up on Mr. Belsky's credit cards or Mr. Haley's employee ID.
What were the retail sales prices for retail bottles of whole water, of the real water?
They weren't much, Your Honor. my client's not here to hear me say it, and I'll deny it if the record accurately reflects this, but everything's a little more expensive at Whole Foods. I think the smallest bottles were about $2, and the larger ones probably went up from there. They went up to a gallon size. I'm not sure any of these stores stock that size. But we actually have some videos to show very briefly, Your Honor, about how religiously Mr. Haley used his employee ID card, because he got 20% off every time he did. And as you might guess from the 5,500 items he purchased during that 3-year period, he didn't often, if ever, make a purchase without that card. He testified to that effect and so did his coworkers. Your Honor, this is data that we didn't make up. We couldn't possibly make this up. No human being could sit down at a computer and do this. It would take years, and there would be obvious discrepancies. And in all of those hundreds, if not thousands, of pages in front of you, and all of those many thousands of transactions, nobody has come forward to say, this one's a penny off, or this one was a date when I wasn't working, or this one is a store that I don't go to, or this one doesn't match my credit card data, which the plaintiffs have unfettered access to. Not a single discrepancy, Your Honor, in all those lines of data, and there's one reason for that. It's because computers don't make the mistakes that I do. And that's an indicia of the trustworthiness, and that's one of the reasons, to reiterate a point the court has made several times now, that there's a hearsay exception for this, and that it's been so broadly applied in the world of information technology, and more specifically, databases and spreadsheets from those databases. There's no misconduct, Your Honor. There was no evidence it was manufactured or suppressed or modified. There was never a misrepresentation to a witness. There certainly wasn't one to this court. We didn't stand on improper objections. We didn't stand on proper objections. We bent over backwards to fulfill every request that the plaintiffs made, reasonable or otherwise, short fused or not. We did what we could. And the plaintiffs have come forward, Your Honor, without an affidavit, without showing the court a discrepancy, without a discovery motion or a meet and confer, without putting this on the special master's agenda, and asked you to strike our answer. And I think that just on a procedural basis, to borrow a phrase from the plaintiffs, that suggests there's something rotten in Denmark, that there may be an ulterior motive here. Now, this motion has evolved over time as the data has become more apparently or evidently reliable. And as the evidence, the only evidence before the court in the form of those 3 affidavits, Exhibit A being Mr. Henfling's, the Associate General Counsel at Whole Foods, Exhibit B being Ms. Anderson's sworn declaration, and Exhibit C being Mr. Shank's sworn affidavit. That's the only evidence, Your Honor. I want to reiterate that point. Those 3 affidavits, the plaintiffs came forward with nothing. Nothing. And since those affidavits have knocked down so many of the plaintiff's claims, that Ms. Anderson substantively modified the data, for example, or that this didn't come from Whole Foods, or that the defense attorneys made up these hundreds of pages and thousands of lines of data out of whole cloth, or that we sat on these spreadsheets so that we could have some advantage over opponents. As those were knocked down one by one, the motions changed. But if you look back at the motion to strike in the statement of facts, what the motion to strike seeks is relief for us misrepresenting this data as Whole Foods data. They say it was wrong to put that bait stamp on there. They say we slipped it in with employment records from Whole Foods. They say that we misrepresented it to this court and to witnesses. Your Honor, we did nothing of the sort. Every single bit of data on those pages before you came from Whole Foods. It couldn't possibly have come from anywhere else. It has UPC codes, store codes, addresses, times of transaction down to the second, dates, quantities, prices. There is more proprietary information in front of you in that binder, Your Honor, than I could possibly imagine. That is Whole Foods data. And if there's any doubt about that at all, Your Honor, we ought to address it at the outset, that data could come from one and only one place. That's the basis for the motion to strike. Substantively, you should not deny it on that basis. Now, as to the disclosure, Rule 16A1, A Romanet 1, requires us to list witnesses we may use to support our defenses. We did that. And I'll show you in just a moment where. Rule 16.1, A1, A2 requires us to describe by category the documents we may base our defenses on. And we did that.
And what was the timing of the production?
Each of those, the disclosure or the production, Your Honor?
The production of the documents that would be attached to the notebook I was given.
The first of them, Your Honor, Whole Foods, and I'll say that unabashedly, Whole Foods 181, that's tab number 2, was produced on January 10th, 2023. Contrary to what you heard yesterday, it was 3 weeks before plaintiff's deposition. The next document, Your Honor, Whole Foods 636, that's tab number 3 in your binder, was produced the day before Mr. Haley's deposition on February 1st, February 1st, 2023. It had been requested by the plaintiffs 10 days before that with a letter. The next document, Your Honor, 637, Mr. Belsky's credit card information was produced on the same day.
That would be 2/1/23?
Yes, sir. $638, Your Honor, was produced on March 14th, 2023. 30 days after it was requested with I believe it was an RFP, it may have been an interrogatory. The next one, Your Honor, 639, was produced the same date, 3/14/23. The next one, Your Honor, 640, was produced on June 5th, 2023. And the last one, Your Honor, 641, the one we were accused of sitting on, was produced the same day we got it, on June 21st, 2023. And that's in Mr. Hempley's affidavit. Each of those, Your Honor, I want to, and I'll go through this in detail, but each of those was triggered not from us, but from a request by Mr. Parker, or Mr. Kemp, or Mr. Pepperman. Those came seriatim as the case went on. And I'll give the court a little color on that because I think it's, again, telling. In January, when we produced Whole Foods 181, the first of the documents, we produced 2 months of Mr. Haley's employment records, employee ID purchases. We did 2 months, Your Honor, because we thought that was extremely charitable. If someone drank a bottle of water 60 days before his hospitalization, maybe he would claim that had something to do with the hospitalization. And there was nothing there. So the plaintiffs asked for a longer time period, a whole year, and we gave them that. That was 636. Then they asked us to supplement that with product names, and we did that. That was 638, which, by the way, includes the sequel, the SQL tab that Mr. Parker said was removed.
How can I identify, and I'm just assuming this, but is that what the card number does, or I want to make sure I'm looking at the headers.
Yes, sir. I'll walk through it and show you that if I can, as we get through each one, or if you'd rather do it right now, I can.
Just in general, because I would
Sure.
imagine they're all pretty much the same.
They're similar, Your Honor. Which one are you looking at?
I'm looking at the last one, that would be transaction details.
Is that 641, Your Honor? The big thick one? Tab number,
I think so. Tab 8.
yes, okay, tab 8. All right, let me, John, can you pull that up, please? And it may be easier to look at electronically, I don't know, Your Honor, but one thing to start with, number one, there are 2 tabs on this document. I don't know if the court deals with spreadsheets often. I try not to. But at the bottom of each, there are tabs. And the tabs, in this case, consist of different things. The first tab, the transaction details that the court's looking at, that lists the aggregated transaction. So if I buy 3 items and it costs $12.43, that transaction is going to be listed as one line. The next tab, which is labeled transaction details, breaks down each of those transactions by item. So another way one could verify this data, if one were really interested in doing that, as plaintiffs strenuously profess to be, would be to reconcile the aggregated transactions, the aggregated transaction details with each transaction. And again, if there were a discrepancy, I'm sure we'd hear about it. But going across the top, Your Honor, on the transaction tab, each column represents a different piece of data for each transaction. So the first one shows the state in which it occurred, the store number.
Yeah, the ones I'm looking at right now doesn't have the state, it has store number though, for example, 10293.
Okay, you're on the transaction details, Your Honor. So you're looking, as you probably should be, at item by item. Store number is the Whole Foods store at which that particular item was purchased. It's got the date identified as the date of the transaction, the date that item was purchased. The transaction time is the military time down to the second. So the first item there is 17:57:57, 5:57 p.m. and 57 seconds. The terminal is the cash register at which Mr. Haley happened to check out that day. The transaction number is a number that would be printed on his store receipt if he had one, so that he could verify it that way. But he could also cross-reference it to the transaction tab if he didn't have a store receipt. The operator is the number of the person operating the terminal, that cashier. The sale value is I believe, the price of the item. The next is whether a unit was returned. That's almost always going to be 0. I don't know what the sale gross means, Your Honor. I apologize. That seems to be almost always 0. Miscellaneous sale, and forgive me, Your Honor, I don't know the next 2 columns again. They're almost always 0s. Then the discount. That's Mr. Haley's 20% discount. So that column refers to the amount of money he saved on that item using his card. The discount's then spelled out, 0.2 or 20%. The next item is his card number, 49400141285. John, could you pull up Exhibit F, page 2, please, his employee ID card. This is the unique employee team member, we say, not employee at Whole Foods, Your Honor. team member card number that's unique to his barcode. And I learned this fact, Your Honor, that the number on the spreadsheet stops at 5. The 3 is missing. And I was concerned about that. And I asked Mr. Shank why they didn't match. And Mr. Shank explained to me that the 3 is a check number. And ID cards often have check numbers on them. The last number is pretend or a dummy number, but you add it to the real last number, the 5, and it ought to match the 8 before that. And lo and behold, it does. It's a way to make sure that there's not a fake ID in front of you, a fake employee ID. The markdown would be a sale item. The payment would be the net that Mr. Haley actually paid.
Any idea what these question marks represent?
Yes, sir. Yeah, I'm glad you asked. No, I don't know that column, Your Honor. Elsewhere, there's a question mark for a null value. And so when there's, and I'll show you an example in a second, when there's data produced with a credit card and a question mark is in its place, that means that a credit card was not used, that cash or a gift card or an employee bonus card was used instead. And I think that's the data on tab 8. There are variations on that theme, Your Honor, but most of the spreadsheets have some or all of those items with a few additions or deletions as a case. It can be printed in a variety of different ways. But I'd like to walk through, Your Honor, how we got to each one to impress upon the court that this is not a scheme on our part, a sword that we used offensively. This was the plaintiffs shooting themselves in the foot time after time as they drew their sidearms. And before I do that, let me press upon the court, if I may, how they knew to keep coming back to us asking for data in a different form or for different dates. It's because we disclosed it. 19 times we said, we have Whole Foods sales data. The first time we said that was in January of 2023. Page 4, paragraph 9 of our second supplemental 16.1 disclosure. That was for Mr. Haley. We said the same thing again in case it was missed the first time on page 7, paragraph 26 for Mr. Fusky. We disclosed a custodian of records who was available and willing to testify and explain to plaintiffs everything they wanted to know about this data, which would have been a great place to start and likely avoid all this. That custodian of record was never noticed for deposition. We disclosed the documents. Page 18, paragraph 34, we said we have Whole Foods sales data. Page 18, paragraph 38, we said we have Whole Foods transaction data. We did that 16 times, Your Honor. January 17th, February 1st, February 22nd, March 17th, March 21, et cetera, et cetera, et cetera. And then we got up to our 18th supplemental disclosure on June 6th, 2023. And we identified all of those spreadsheets, all of that data. We correctly said it's Whole Foods data. And we identified Mr. Schenk by name. Page 10, paragraph 32, Exhibit N to our opposition. Our June 6, 2023, 18th supplemental 16.1 disclosure. Now you'll recall, Your Honor, we're here on a motion to strike because we mischaracterized this data as Whole Foods data. Again, I hope we've just proven that's the court's satisfaction. But that's why the plaintiffs knew to keep coming back to us and say, we want the data in a different flavor. What you gave us is great, but we need more. What you gave us is fine, but we found additional credit cards. What you gave us is good, but our doctors say the latency period might be longer than 2 months. Maybe it's a year. Maybe it's 3 years. In the next case, maybe it'll be 5.
Do we know what the ESI protocol was as it pertains to the preparation of the, for example, I'm looking at, I guess it would have been Appendix 8, and this would be Whole Foods 000000641.
Perfect example. Mr. Stevens, could you pull up Exhibit L? There was not an ESI protocol, Your Honor. The special master offered one, and my recollection was that the plaintiffs weren't interested in that. You go to what we got instead, and it's on the screen right now, Your Honor. This is the plaintiff's second set of requests for production to UNFI in the Gallagher case. It's dated March 31st, 2003. And this is what eventually led to the production of 641. John, can you go please to page 4, paragraphs 3 and 4, and pull those out for us? This is what we have instead of an ESI protocol. This is from the plaintiffs. We want you, UNFW, in responding to these requests, to furnish printouts of documents which may not currently exist in hard copy paper form, but which exist in electronic form, as email, or as a document, or as a file, generated by word processing, a database, or spreadsheet software, and which are stored electronically on a floppy disk, a compact disk, a zip drive, a personal computer hard drive, a network server, a backup tape, a disk, or any other electronic medium. Ms. Anderson did exactly what you would do reading that, Your Honor. She said, I'll give them what they want. Now, what we should have done, probably, is just printed out PDFs. Because that's what they asked for, but we went above and beyond. And we gave them a native Excel file that they could sort, and filter, and search. And this is what we get for that trouble. In paragraph 4, instruction number 4, we were told, if an electronically generated document does not currently exist as a hard copy, and if it has been deleted from the hard drives of your personal computers, you are requested to retrieve it from any other electronic medium. For example, a network server or a backup tape disk from which is retrievable. Your Honor, you'll recall Mr. Shank's affidavit, Exhibit C to our opposition. Mr. Shank explained that each cash register records the electronic data contemporaneously and then transmits it daily to the Whole Foods warehouse data server maintained by Teradata. We can't go to a cash register and get the daily purchases from 4 or 5 years ago. That data's not there anymore, it's overwritten daily. But we can go to the warehouse, the data warehouse, and get it from the server that Mr. Shank identified. And that's exactly what we were told to do in instruction number 4, and that's what Ms. Anderson did to her great credit. And at great expense of resources in terms of time and effort and money. There was not an ESI protocol, Your Honor. Instead, the plaintiff unilaterally dictated the terms under which this data would be provided.
And what terms would that have been? I just want to make sure I'm clear.
Furnish printouts of documents from database or spreadsheet software that is stored electronically. And if it's not on the original personal computer, go to the backup server or tape. The binder full of the 8 tabs in front of you, Your Honor, is the embodiment. It's the result of. They comport with the instructions the plaintiff gave us in every single regard.
So the documents as produced, would they be the same as if they were kept in the usual course of business?
Absolutely. And I'll refer you, Your Honor, to several sources.
And so how would that be if they're Excel spreadsheets?
It's a great question. And Your Honor, I think The law here has evolved in a manner that reflects modern day information technology. This may shock Mr. Kemp and Mr. Parker, but Whole Foods doesn't have a file with my name on it, or Keith Haley's name, or Richard Belsky's name, into which they put every receipt at every store, and which I may shop. What they have instead are the Teradata servers in the data warehouse, into which that same data, infinitely more detailed, goes. And it goes there daily. It is contemporaneously recorded at the time of sale, either by Mr. Haley himself in a self-checkout, or by the cashier. And actually, Mr. Haley can't do it himself, but he's getting a discount. That data is ordinary business data, Your Honor. Whole Foods relies on it every day. The first time they rely on it under duty of law when they hold their hand out to you and say, that's $86.43. And my suspicion is, Your Honor, if that data weren't accurate, there'd be a pretty significant class action suit or regulatory problems or criminal charges or all of the above awaiting Whole Foods. But they also use that data every day to decide where to put items on the floor, what stores to keep open and closed, how many people to bring in to work and when. That is that is data kept in the ordinary course of business. Now, in a case like this, Your Honor, what happens is, of course, we can't deliver every transaction at every Whole Foods from the beginning of time on a thumb drive, as was suggested by the plaintiffs in their motion. It has to be sorted. It has to be narrowed down. It's a relational database, and that's the advantage of keeping data in a relational database, is that it can be carved up by store, or by individual employee ID number, or by credit card number, or by UPC code, or a dozen different ways I'm probably not smart enough to imagine. And so what I think I hear Mr. Parker saying is that he now wants an itemization of the cash purchases that occurred at a certain store at a certain date range. And I don't know whether that's attainable or not, but that's the kind of analysis that a relational database allows you to do. If I push print on that data, Your Honor, that's a business record kept in the ordinary course, even if I do it years later. And here's the case law I refer you to. You said yesterday, or perhaps it was the day before, that Wright and Miller is your favorite. Section 68.
It is. I don't have Wright and Miller, but I
Okay.
have Morris Federal Practice and Procedure. We
Well-
can't afford Wright and
Well,
Miller.
then, if we're doing it
I
on a
can find
budget.
it. I can find it.
No, Judge, look, we've got both for you. If you're going to Moore's, go to section 4.11. 3, B as in Bravo, Romanet 6. 4.11, 3B6, footnote 70. That section of Moore cites the U-Haul case.
That was footnote 70.
Footnote 70, yes, sir. And it's more, and if you do get lucky and stumble upon Wright and Miller, it's section 68. 68, same case, same proposition, same bedrock principle of law, which is when you're looking at a spreadsheet and determining whether it's kept in the ordinary course, you don't look at the date it's printed. You look at the date is made. And this happens every day in the courtroom without most of us probably realizing it. We cited 3 cases for that proposition. The Fuji case, 301 F3rd at 539, which says computer data compiled and presented in computer printouts prepared specifically for trial is admissible under Rule 803-6, even though the printout themselves are not kept in the ordinary course of business. We also cited the Weinstein treatise, the U-Haul case that I just talked about. And
What was the site again on the U-Haul case?
the U-Haul case, Your Honor, is 576 F3rd, 1043. Here's what Weinstein says about it. Quote, printouts prepared specifically for litigation from databases that were compiled in the
I'm sorry, I apologize, Mr. Neale. Could you please put that back on the screen that you just had? Just one sec. No. Thank you very much.
The Weinstein Treatise, Your Honor, says, quote, printouts prepared specifically for litigation from databases that were compiled in the ordinary course of business are admissible as business records to the same extent as if the printouts were themselves prepared in the ordinary course of business. The important issue is whether the database, not the printout from the database, was compiled in the ordinary course. And then let me show you an example of where we see it more typically. Mr. Stevens, can you pull up Gallagher 01369, please? Your Honor, when we request medical records and medical bills, we get them from databases. We don't get the original bill that's handed to the plaintiff or the patient. We get something that comes out of a relational database. This is one from young Mr. Gallagher, and it shows a variety of dates of service and a variety of payments and insurance adjustments made on it. And can you scroll down to the bottom, John, so that you can see when it's printed, the footer, please? Each and every medical bill we get comes from a relational database, and it's essentially a spreadsheet. It's printed long after the fact in response to a request during litigation for that specific document. Mr. Gallagher's financial bills are floating around with those of millions of other patients in one giant data set. And it can't be produced as one unit. It never is. Instead, somebody serves a SQL query to it. That query yields responsive data. The responsive data is the underlying data from the credit card machine in the doctor's office or the cash register in Whole Foods. And it's printed after the fact, even though the data was born contemporaneously with the transaction. This is modern day life in America. Medical records are done the same way. Gallagher 0362. These are the first two records I stumbled upon. They both show the same thing. Top, if you could highlight the top, please. Date of service, September 5th, 2019. Top left corner. Printed 2 years later, August 2021, for this litigation. Nobody would require Mr. Kemp to go back to the database and pull the original records. That would be absurd. The original records don't exist anymore. But the data's archived and preserved and unmolested in every form. And that's another thing computers do much better than we do. They have a perfect memory for this stuff and infinite details. And so that's why I was going to say cute, that sounds denigrating and I don't mean to be. That's why the catchy emoji of the haystack in the plaintiff's motion is ridiculous. Because the computer can search a haystack that's beyond the size of our imagination just as quickly as it can 556 separate transactions that Mr. Kemp wants us to go back to the store that don't exist in the store anymore.
So tell me this, why would the ESI protocol not be discoverable?
Oh, it is. I think it is, Your Honor. The SQL query.
Well, I mean, but it wasn't produced.
It was, Your Honor. It absolutely was. Mr. Stevens, can you please pull up Whole Foods 638? Here's where I'll come clean with the court. 636, 637, Your Honor, the first two of the first spreadsheets that were produced. They were produced from Whole Foods with an SQL tab on them. I mistook those for work product, and I directed Ms. Anderson to take those off. So 636, which is Mr. Haley's 2019 purchases, does not.
Which tab is that again?
636, Your Honor, is tab number 3. And 637 are a few transactions for Mr. Belsky. Those were the ones that were both produced on February 1st, the day before depositions began. So on those, Your Honor, I, Jim Neale, not Ms. Anderson, decided that the SQL tab, and I'm told that computer programmers say SQL, not SQL.
Yeah, so they say SQL tab.
The SQL tab, yes, sir. The SQL tab was removed from those two spreadsheets at my direction. All right, now, fear not, because John, if you could go to 638, please. And this is gonna be on your screen, I think, better than it is the paper, Your Honor. But you'll see at the bottom, can you go back to the original, John? This is 638, Your Honor, which is, let me remind the court, 638 is the same as 636, but at the plaintiff's request, we included column L, the item description. Because previously, 636 reported just the UPC code, that number to the left. And Whole Foods knows what UPC codes mean and can search for real water. But that was more of a chore than we should have asked of the plaintiffs. They were right. They came back and they said, we want you to reproduce 636 with column L, with the item names. So we did that. Now down at the bottom, you'll see a tab that says data. That's what we're looking at now. Those are the individual items that Mr. Haley purchased the entire calendar year of 2019 with his employee ID card. John, can you, let's, if we could, Judge, let me take 1 minute and go through some of this. We have a date in column A, store number in column B. We have you're right, I'm sorry. We can stick with 638. I had them backwards, Your Honor. 639 is the one I should have said, but 638 also has the SQL tab. These are Mr. Belsky's. Thank you, Ms. Anderson. She knows the data better than I do, but 638 are Mr. Belsky's 2018 credit card transactions. The terminal is the cash register number. The transaction is each payment is a separate transaction. So the ones labeled 14335 are one transaction. I don't know, I'm sorry, what column E is, but column F is the time, the time block in which that occurs. And let me go back, I'm sorry, I misspoke here. Column D is a time. It's expressed as a 5-digit number, but it's 14:33 hours, 2:33 p.m. And that corresponds to the hour of military column in F. We have the store number again in G, the terminal number again in H, there's some repeat. We have a store name that Mr. Haley or Mr. Belsky could have verified the data with. We have the region in which that store belongs. We have a UPC code, which is, you can Google on the internet. That's the numbers below the barcode on every consumer packaged good we take through a scanner. We have a long description of each item, the size of that item. For example, the first item is the Tulsi Original Tea, comes in an 18 count case. We have the department from which that comes. The sub-team within the department, that comes from the candy snacks part of grocery, in case you wanted to know that. We have the, whether it's a local item, whether it's sourced through the distribution network or from the store itself. We have a card number. This is a vestige of a credit card number. First 6, last 4. So Mr. Belsky could take that data, Your Honor, and compare it to his banking records and see if there's a single penny that's off. This is all cross-referenceable, it's all right there. It can be checked a dozen ways to Sunday. The number of units he purchased and the sale price are columns S and T respectively. Now, you asked about the SQL data that I mistakenly removed from 636 and 637, which we'll be glad to produce to the court, to the plaintiffs, to both. But it's on 638 and 639. Mr. Stevens, could you hit that tab? This is the computer code language that Mr. Schenk used, that Mr. Parker says he doesn't have, that shows exactly what search was used to query the Whole Foods warehouse data system. It's all right here in black and white. And 639, the one for which we did include the SQL tab, is identical in substance to 636, the one in which I mistakenly asked that it be removed as work product, because they're both Mr. Haley's 2019 purchases. One has a product name and one does not. There is absolutely no harm here. I don't think there's any foul, but there's certainly no harm. And I think anybody who had spent any time with these spreadsheets, with this data, would know that the two of the biggest contained the SQL data before they came into court and maligned their opposing counsel and accused them of wrongfully suppressing evidence. There ought to at least be a phone call before that happens in my book, Your Honor.
What about cash?
Let me go, can you go to 639, please, Mr. Hayles? We won't have cash from Mr. Belsky, and I'll show you the discovery request in a second. And we have never, ever represented that we would have a cash purchase from Mr. Belsky. If an ordinary consumer walks in off the street and pays cash, that transaction is not associated with any particular unique identifier unless he or she uses his Amazon Prime account. To link it to a person, we need an employee ID number, an Amazon Prime account, or a debit card, debit/credit card. But for Mr. Haley, our employee, who used his employee ID number, that's column O, John, can you highlight that for us? This is his very well-worn, barcoded, never forget it, never leave home without it, 20% off discount. Every time he uses that, whether he uses cash or credit, the transaction's recorded. Column P, please, John. Primary token. Mr. Shank's affidavit makes clear that what Whole Foods does, they don't store your credit card number, Your Honor, you can rest easy. What they do instead is they assign an algorithm to it. And the algorithm adds some secret code to your credit card number, and a token, a random token is generated. But that random token is the same for one particular credit card. So if somebody hacks into the system, they don't get your credit card number, instead they get a random token that they can't do anything with. You'll see the same random token assigned to Mr. Haley's credit card everywhere there is a 9.91799 and then E to the 15th. That goes on for 15 more places. It's a fairly sophisticated cyber protection mechanism. The question marks there are null values. That means Mr. Haley did not use a credit card when he bought the beef pork stick on January 1st, 2019 to celebrate the new year. He either used cash, or perhaps a gift card he'd been given for Christmas, or perhaps a WOW card, an employee bonus card, for a particularly good customer service that his manager gave him. But what you were told yesterday about cash not being on here is not correct. It's no more correct than was what you were told yesterday about the SQL tabs being missing, or about these documents being produced on the eve of the deposition. These documents were produced, Your Honor, and I want to run through this quickly, but I think this is really important. These documents were produced not because we thought they'd be good for us. We weren't trying to prove plaintiff's purchase of these products. These documents were produced because plaintiffs asked for them. One caveat to that. We did produce 181, as I've said before, the 2 months of data for Mr. Haley prior to his hospitalization. That's the tab number 2 in your book. Everything after that. Oh, and let me do this, Your Honor. John, can you please play Haley 1? These two plaintiffs, Your Honor, looked at these documents, and they immediately recognized these items. They authenticated this data. Haley, video clip one, please, John. Do you have any idea what this document is, Mr. Haley?
List like purchases,
Whose purchases, sir?
my purchases.
And why do you say it looks like your purchases?
Because they are.
You recognize the items here as the ones you bought as an employee of Whole Foods, correct?
Correct.
Using your employee discount
Correct.
number.
Yes.
Belsky, video clip number one, please. All right, and what is your understanding? Let's call that Exhibit O, please. And for the folks on the phone, this is, I'll pull it up, but it's base number. Whole Foods 0000637. This is tab number 4. What do you understand that to be, sir?
For foundation. I understand this to be a list of the items I purchased using that specific Amex card on the dates that you just referred to on the screen.
Right. And these, it contains a column L, long item description, or item long description. And do some of these items look like your shopping habits or tendencies or things you would have bought?
Yes.
We're not bullying the witness, Your Honor. They're identifying their own purchases. They recognize them. And this is how we know that these are true and complete. We solicited every possible credit card Mr. Belsky could come up with. Before his deposition, after his deposition, I think there were 4 or 5 or 6 credit cards. For Mr. Haley, it's even more conclusive. Never without, John, that video clip, please. And did you do that here?
Yes.
You did. You would have scanned your employees
Here's my discount card
every time you bought real water that you can recall.
that I can recall. Right.
And have you ever seen that system fail? Not register your employee ID number?
No.
If you don't think Mr. Haley's an accurate historian, maybe we'll accept the opinion or the observations of his coworker. Ms. Kingston, very consistent, Mr. Stevens. You don't ever recall checking out Mr. Haley in the more than the decade you've worked with him without him claiming the employee discount, which is entitled.
He is very consistent about producing his discount card.
Okay, and I don't mean to press you on it, but specifically during all of those 10 or 12 years, or 12 years, you can't ever remember him not having this card with him when he bought something.
I do not recall him not ever having it.
That's why both parties had such absolute confidence in this system, because of what the plaintiff said. Now, Exhibit H, please, John. Just to show the court quickly where this sanctionable conduct arose. This scheme, this diabolical scheme that Mr. Neale hatched. Well, it arose from a request by the plaintiffs. Last paragraph, please, John. We want Haley's receipts or itemized transaction histories for 6 months prior to your previous production. I told you that we gave them June through August. They wanted January through August. All right, I'm sorry, they wanted December. Due to Mr. Haley's forthcoming deposition, we request that this information be collected by January 26th, so as not to delay it. Can you back out to the date, John? This was January 20th, Your Honor. The data, I didn't make the January 26th deadline, I made it 5 days later. 20th was a Friday. But, that request, Your Honor, is not limited to a store. And I want to point that out to the court. There's no way we could have complied with the plaintiff's request by going to a store. If I had produced the data that Mr. Haley purchased from one store, and there was a purchase at another store, I'd probably be facing a motion for sanctions. That would be me deciding what the plaintiff should get, and I didn't want to do that. Ms. Anderson didn't want to do that. So we produced everything from all Whole Foods stores, so that if Mr. Haley was on vacation in Los Angeles and picked up a bottle of real water, it would have been there. And so that when Mr. Belsky went home to be with his mother the summer of 2020, that if he happened into a Whole Foods and purchased real water there, it would be recorded. This is characterized, the data that we
And
provided,
I want to make sure I'm clear, tab 2, that was produced by Whole Foods originally?
all of these documents were.
No, I understand that, but I mean, I should say it this way to be clear. Tab 2 represents productions made by Whole Foods as it pertains to the time period, which would have been 60 days before?
Yes, sir. And when you say production by Whole Foods, I need to be very precise so I don't get another motion for sanctions. It was produced to us, that is UNFI, and UNFI in turn produced it without modification to the plaintiffs. Because, of course, Whole Foods is not a party in this case.
I understand.
Now, we got this data in 10 days. This is described by the plaintiffs as an ambush when we gave them this data. We jumped through hoops, we got it to them before the deposition, and they're the ones crying foul. No request for production of documents. We could have ignored the letter and insisted on a silly formality. We didn't. We could have said Whole Foods is not a party here. We didn't. We got a letter and we did the right thing. That detailed 853 transactions and 2,644 separate items, not a single purchase of real water. That was followed up, Exhibit I, please, John, 2 weeks later. February 24th, 2023, another letter from plaintiffs. If you could just highlight the bottom of the first paragraph, please. And this is where I told you, Your Honor, we should have and didn't give them the item description. And they asked for that, and we, of course, obliged. 30 days later, we provided 639, which has the sequel tab, which has the item description, which complies with their instructions on discovery, and which shows every single purchase of Keith Haley in 2019. Same 2,644 items. It shows the time, which I thought I heard Mr. Parker say yesterday was missing, and deprived him of the ability to compare it to employment records. It shows cash purchases, it shows credit card purchases. Nor is this request limited to one store. I can't go to one store and fulfill my obligations under the rules in satisfying this request. We didn't insist on a formal request. We didn't say Whole Foods isn't a party. We jumped through a bunch of hoops, and within the 30 days that would have been allotted to us, we produced additional data. Data that has the sequel code. Data that, expert rebuttal report, please, John, page 9 and 10. Data that the plaintiff's experts used offensively. This is Dr. Hudson's rebuttal report. And he takes the defense causation expert to task. Last paragraph, please, John. And he examines the purchase data. The same purchase data that the plaintiffs are telling you is unreliable. And he says, well, I can use it to prove that green tea is not a problem. That the green tea Mr. Haley bought at Whole Foods didn't cause his liver injury. So the data's apparently reliable when it suits plaintiff's purposes and unreliable when they realize, oh shoot, this sort of defeats our case. Exhibit L, please. March 31, 2023, discovery. RFP 11 on page 6, please, John. Well, we haven't found it yet in 2019, but let's keep looking. Let's go back even farther. This is the plaintiffs to us demanding 4 years worth of data. Not from one store. That's what we produced at 6:41, Your Honor, the very same day we got it. 5,503 separate transactions. That's the one that showed the 1 half-liter purchase, and I'm almost done. The court's been very patient. Exhibit J, please, John. Another discovery request. This is Mr. Belsky's discovery. This was served in December 2022. I want to point something out here. This was served in the Brown case, where Whole Foods is a party, because I think the plaintiffs were concerned that Whole Foods might not do what Ms. Anderson told them they should do and produce the data if it wasn't in the case in which they were a party. And we didn't say, wait a minute, Belsky's not a plaintiff in Brown. Come on, guys. We didn't waste time to make them spin their wheels. We answered the discovery. We answered it exactly the way they wanted it. Page 4, interrogatories 12 through 16, please, John. Mr. Belsky identified very specific credit card transactions from his banking records. He said, give me all the data you got on that. They weren't store specific. And we did it. That's what resulted in 637. And that's what enables Mr. Belsky to true up the data we provided with the credit card data he already has in hand. It would be an idiot of a lawyer who would try to fake this, Your Honor, because it's so easily disproven. No real water purchases. When Belsky was deposed, he identified 4 more credit cards that he hadn't given us before, that he only started looking for once he saw that these didn't yield what he expected them to. Then he gave us still other credit cards. And I won't belabor the point, Your Honor, but Exhibit K are additional discovery requests. And then I'll wrap up with this. This is Whole Foods data. The 3 sworn affidavits, the only 3 sworn affidavits, or 2 affidavits and 1 sworn declaration in front of the court say that. Craig Shank at paragraph 29, John Hempfling at paragraph 11, and Sanderson at paragraph 5. They're not, as the plaintiff said in their papers to this court, without a meet and confer, and without a motion to compel, bogus or fake. They're not a concoction, a trick, they're not deceit. They're not misrepresentation, they're not a ruse, they're not a lie or a scheme. And I find the allegations offensive. They're true and accurate and complete. That's what Mr. Shank said, Your Honor, at paragraph 29, I believe, on page 11 of Exhibit number C. And the way he knows that, Judge, is because he went back and did a forensic electronic comparison of everything we produced in this litigation to what was generated from his SQL queries, and he found absolutely no substantive modification at all. He found that Ms. Anderson changed the file names, as she should have. And he found, that I directed the removal of SQL tabs from 636 and 637, but then included them in 638 and 639. And I'll reiterate the offer to produce the removed tabs from 636 and 637. This is store data. It can't possibly come from anywhere else. This is the underlying data. That's what Mr. Shank says at paragraph 18 and 19. This is collected in the ordinary course. Mr. Shank says that at paragraph 14 and 29. Mr. Hempfling says that in paragraph 12. This is not prepared by counsel. This was not modified by counsel. This is true and accurate and complete, Your Honor. And unless the court has questions, I'll leave it at that. But I also want to finish by, again, as unequivocally as I can, say that this has been a very unpleasant episode. I think it was entirely avoidable. I wish there had been a meet and confer or a deposition that were noticed or a simple conversation, and I think we could have saved the court an awful lot of time. Any questions, Your Honor?
Not at this time, sir.
Thank you.
Thank you, sir. We'll take a break.
All right.